In our first case this morning, 2024-1043, State of Ohio versus Gurpreet Singh. On behalf of the appellant, Ms. Sanford. Good morning.
Thank you. Chief Justice Kennedy, and may it please the court, on behalf of appellant Gurpreet Singh, I'm Catherine Sanford. I would like to reserve 7 minutes for rebuttal. Okay, thank you. For today, I would like to start with propositions of law 3 and 4 from our brief. And proposition 3 is that defense counsel were ineffective for advising Mr. Singh to waive a jury. As we know, the first trial resulted in a hung jury. The second set of attorneys who were appointed, they were adamant on having a jury. The third set decided on a 3-judge panel. It doesn't make sense when there was a hung jury at the first trial in this case. And as we know, all it takes is one juror, as happened at the first trial, to block a conviction. And if a mitigation phase takes place, it also just takes one juror for death not to be imposed. And obviously, 1 in 12 is better than 1 in 3 with a 3-judge panel. And with a jury, there are 12 unbiased finders of fact. And with a 3-judge panel, in this case, there were really only going to be 2 unbiased finders of fact. That's proposition 4 that I will get to in a minute, because Judge Howard was, again, the presiding judge.
By unbiased, you mean he had heard the facts before?
That he had heard the multiple different statements from the defendant by that time, and he made a couple comments about the evidence. When he was denying the motion to declare an acquittal at the end of the first trial, at the end of the hung jury, he stated, "I do agree with the state of Ohio that I believe that there was ample evidence for a jury to unanimously agree. Unfortunately, this jury did not make a unanimous finding in regard to this matter. But given the publicity in this case, and they knew that saying that the vote was 11-1. So that he already knew, he believed that there was, ample evidence to convict. And with the state presenting the same evidence at the second trial, he already had found him guilty before he even heard anything by that statement."
Thank you.
Can I interrupt?
Yes.
The statement said there was ample evidence for the jury to make a decision, not to find, that he did not say that there was ample evidence for the jury to find the defendant guilty.
He said for the jury to unanimously agree. Unfortunately, they did not unanimously agree.
But we don't know if he meant to unanimously agree on acquittal or unanimously agree on conviction.
Well, when he's stating that the vote is 11-1, I guess we assumed he meant for conviction.
But he did not say that.
He did not say that, no. And with the jury waiver, another reason is because there was a jury on this case, and the jury was not unanimous for a conviction. And if any reason was, well, you might waive jury because of gruesome photos, testimony, that kind of thing, a jury heard all of that and still did not convict him. And also diversity in the jury. We know at the first trial there were women on the jury and 1 African-American juror. And the 3-judge panel did not have that same diversity at all. The judges all, they have the same job, work at the same place, know each other, live in the same community. The chances are good that another jury would have had at least 1, if not more, women, a non-white person, maybe even an Indian or Punjabi member.
Are you saying that all death penalty cases have to have juries?
No, I am not, Your Honor.
Then what's wrong with 3 judges?
And nothing is wrong with 3 judges, but in this case, that was not an effective decision. Because he'd had a jury on this case, and it came back with a hung jury. There's no reason to waive a jury. He wasn't gaining any benefit by that. And at least if you're going to waive jury, go through voir dire. Go through voir dire and see who the jury members would be. You can waive jury up until the jury is sworn. That's, I think, how you would knowingly and intelligently and voluntarily really make that waiver. How do you know what you're waiving? See what it is that you're waiving. And by going through voir dire, you would see, is this a jury that you're happier with than you would be with the 3 judges? Did I answer your question, Your Honor?
Yeah.
Okay, thank you. And also, as the state said in their closing argument at the end of the trial about the judges, the end of the second trial, I'm sorry, Your Honors, basically, Your Honors have handled a multitude of criminal cases like this. You see things that seem irrational all the time, but basically you can see through it and you can find the person guilty. And again, that's saying that you judges, not you judges, the judges there, have familiarity with this, they see this kind of thing, and they can see through it. Whereas if you have a jury, they're not going to have that familiarity with anything like this. I mean, they don't have a criminal docket. So they would really be an independent, finder of fact in this case, unlike the three judges.
Were the photos before the three judges any different than they were before the jury?
No, Your Honor. No. And also, the state says that at the first trial, there were 11 jurors who would vote for conviction. But again, that doesn't matter. There could be 50. You just need one who is not voting for conviction.
I mean, isn't it reasonable? I mean, couldn't
Sorry.
it be reasonable to think that there's some really gruesome facts in this case, that judges see gruesome facts all the time, juries don't. Judges are going to be less likely to be swayed by kind of the circumstances of the events here?
Yes, however, in this case, it's different because there was a jury that saw all of that, and there still was a holdout for that. He still was not convicted.
But no one knows the next jury is going to be different or the same. There was one holdout, but there were 11 people on the jury that would have found him guilty the first time. That might give someone pause about going back to rolling the dice again with the jury.
It might, but again, that's part of why I'm saying that they should have gone through voir dire, see who the jury is going to be, and then they can make an intelligent decision about that. Because, again, if you had one holdout at the first jury, I'm not saying it's absolute, but there's a chance you would have had, others at a second jury.
Yeah, but there's a chance that you'd be a holdout in the three-judge panel as well. I mean,
Yes, but I still.
mean, it's hard to say that calculation was ineffective, just because in this case, the three-judge panel ultimately decided to convict and impose a death sentence, but the attorney didn't know that going in.
No, but again, why not go through voir dire and see who the jury members are going to be? You might be so happy with the jury that, of course we're going to go with the jury and not a three-judge panel. But they didn't make that assessment. They didn't go through voir dire, which seems unreasonable when you had a first jury where there was a holdout. Did I?
Just go ahead.
Oh, okay. Thank you. And, excuse me. And again, that there was one holdout, and, you can have as many hung juries as there happened to be. In State versus Anderson and Mahoning County, there were 4 hung juries. And so if the second case was a hung jury, that's still better than a conviction. And the state points to this court's holdings in Hunter and Belton, where the finding was not ineffective assistance for waiving jury. But this case is different because there was a jury and this was a retrial. And so the jury already saw the gruesome photos, heard the testimony and everything else from the first trial, yet they were not unanimous for conviction. And then I'll move on to the fourth proposition that we were already speaking about, where counsel were ineffective for not moving to have Judge Howard recused. First of all, he heard the 3 different statements by Mr. Singh, the one to the police, the opening statement of counsel at the first trial, and then another scenario at the second trial. And, excuse me, and his statement about he agreed that he believes that there was ample evidence for a jury to unanimously agree. I know it doesn't say convict, but to agree. So he's already made findings himself on the first phase, on the trial phase. So when you go to a second trial, he's already heard everything, he already knows how he's going to find, and that is not an independent fact finder. And he's no longer obviously the person who just rules on questions of law. He's now a trier of fact. And he made other statements such as counts to the state, actually to the state, in response to a motion that if trial counsel at the second trial went forward with the same two people who they say could have done it, he says to the state, you all produced enough evidence that rebutted those two people not even being in the state. So if defense counsel goes with that theory, aren't they at their own peril of providing a defense that you already have an answer to that can show conclusively that those people could not have been involved because they're not even in the state of Ohio at the time these murders occurred. So he's already decided that that theory of those two individuals that first trial counsel asserted were responsible for this is not valid. They were not in the country. So then when second trial counsel, they present that same defense of those two people, I mean, he's already made his findings, so he's no longer going to be impartial. He's already found against the defense for that. And to be recused, the judge needs to have formed a fixed anticipatory judgment on any issue in the underlying case, and he already had. I mean, we thought that his statement about the jury and unanimity was one, but the one about peril, that saying the state has proven those two people were not here, he's again not going to be independent about the defense. And they presented the same defense at the second trial. And even if, and plus, because he's already heard so much from the first trial that he cannot, and he's showing his statements here, what I just read, he has not forgotten what he heard. It's not like he can just put that out of his mind and move on. So our argument is that he was prejudiced by the attorneys not seeking to recuse him from being a trier of fact at his retrial. Another proposition I would like to talk about is Proposition 2, that the waiver was not valid, that Mr. Singh signed. And we screenshotted the waiver used in Brinkman's case that said he's waiving jury for the trial and sentencing phase. And Mr. Singh does not say anything about the sentencing phase. And we feel that that is an error. And he was not instructed he could withdraw his waiver at any time. And I know that on the record, the judge goes through, basically with counsel, that if we're still having a jury, if we're still going to have a jury, if he waives this, but he's never really addressing Mr. Singh. And the fact that he also was going through juror excuses, juror questionnaire, having the jurors show up until the day trial started. I mean, Mr. Singh is not going to understand, oh, I'm not still having a jury. I mean, they're there. They keep coming there. And that's not going to be a valid waiver. And the waiver was secured, was the word that they used, on November 14 of 2023. The trial wasn't for 5 months. And in the meantime, again, the jury still keeps showing up. So he's not going to understand that. English is not his first language. And people who don't do what we all do and understand the procedure of all this, they aren't going to understand. It'd be like, you know, if I don't understand what antitrust lawyers do or what mechanics do, it'd be like he's not going to understand this. None of this was an effective waiver for him of his right to a trial by jury. And the statute talks about, well, the statute was in effect, has been in effect since 1953, talking about that you're waiving your right to a trial by jury. But in death penalty, we call it a trial phase and a sentencing phase. And that's why the waiver in Brinkman was more accurate. It should be called trial and sentencing phase, not just trial, because it means something different. And also in the statute, it says, you know, the waiver may be withdrawn by the defendant at any time before the commencement of trial. But that was not stated to Mr. Singh. It was stated to attorneys. Mr. Singh was in the courtroom, but it was not stated to him, do you understand you can give this up and you can take back your jury waiver at any time. And also, Mr. Singh was improperly instructed on the weighing process. The judge kept saying if the aggravating circumstances outweigh any of the mitigating factors, but it shouldn't be any, it should be all of the mitigating factors because they are to be weighed collectively. Nor do they say if the aggravating circumstances are equal to the mitigating factors that you also get a life sentence then. And as this court stated in State versus Tenace, viewing the evidence collectively strongly militates against, with the mitigating factors having to be collective, Tanay says that a single one of these facts standing alone would not establish that, but viewed collectively strongly militate against imposing the death penalty. With the instructions of Mr. Singh being inadequate and the jury waiver not being adequate, I mean, that's a structural error in the jury waiver. With Proposition 1, we argued that the unrelated firearm and ammunition should not have been admitted into trial. The state admitted it was not relevant. It was for the limited purpose of showing Mr. Singh had access to it.
Didn't defense counsel first raise that issue over here?
I'm sorry.
Didn't defense counsel first raise that issue in the opening statement?
They did, but opening statements are not evidence.
They are not.
They are not. He
But
said,
they show reason.
pardon me?
They show reason that a lawyer would put on evidence.
I'm sorry, I'm not following.
Well, if the defense says the Ruger, I think it was a Ruger 9mm or whatever, wasn't used, right? There was some statement to that effect. Then the state's going to put on evidence why, that it existed.
Well, what's interesting about that is the state points out that it's not relevant. They point out the gun found in his closet is not relevant. It's not relevant to this case. And I didn't know until the reply brief the reason for even admitting it. I just thought they were admitting to say he has a gun, and not sure why. And it wasn't until they were saying, but it shows if he came home and found the victims, the victim's deceased, wouldn't he go and get the gun out of his closet? But that's not his statement for the second trial. That was from the first trial. So it's not even the correct trial when they were, making this assertion. And because when he said the second trial, he was home when people came in and shot everybody. And so the reason the state sought to admit the gun was not relevant, and it wasn't part of the same trial. And all it showed to us was that, it shows if he can get one gun, why couldn't he get a second gun? The one that was found in the pond.
The state, I think itself asked, cautioned the panel that it could only be considered for a limited purpose, right?
Yes.
Don't we presume that the panel followed that?
But when it's not relevant, they shouldn't have admitted it at all. It had no bearing on the case. And again, their theory was that he came home, found the victims, came home. He wasn't there when it happened, was the theory. Came home, found them deceased, but that's not the statement at the second trial. The second trial was he's home when these people come in. So what might have made more sense, I guess, for the first trial didn't make any sense for the second trial, because it was a different theory that the defense had asserted in opening statement.
But if you've heard opening statement before by defense counsel, isn't that the reason that the state provided this evidence?
No, because in their reply brief, they say they were providing it to show that if he really cared about people here, I might be paraphrasing.
Right.
And he comes in the house.
He would have gotten that gun.
Yeah, he would have gone to get that gun to try to arm himself, or if the shooter was still there or something. But that's not the situation at the second trial. Opening statement from the defense says he was there when the shooting started. So he wouldn't need to, it wasn't the same theory, is what I'm saying, is that what might have been more relevant at the first trial was not at the second trial because it was a different theory.
Wouldn't it also be relevant to show that he had familiarity with the same caliber of semi-automatic handgun used in the shooting?
That is not what the state asserted. That's not what the state asserted. And, if you want to, he could have, if it was him or whoever, could have used the gun in the closet, but didn't. There was a Ruger.
Right, but that's might help the defense, as you say.
But admitting it at the second trial to show he has a gun, again, that it was prejudicial because it shows if he knew how to get one gun, he could go get another gun, the gun that was found in the pond. So that's why we believe it's prejudicial. And again, not relevant. As the state admitted, it wasn't relevant. And their theory, as I said, the theory for it was not from the right trial anymore, or the right defense anymore. Because first trial and second trial had a slightly different defense. Not different defense, I'm sorry, statement of facts, statement of what happened.
But the state didn't know that when it presented its case. What the state knew was what the counsel had said in opening statements.
An opening statement for the second trial, counsel said he was home when people came into the apartment and then shot people. And so, no, their theory was the relevant.
But he also raised the issue of the other gun in opening statement.
But that was not evidence.
Well, again, but when the state presented its case, that's all the state. This defense hadn't presented their case yet, right?
Right.
So, the opening statement, the state says they're going to raise, the defense raises this. Seems pretty reasonable for the state to put on evidence about what they say their case is going to be.
They said in opening statement, there was a gun in his closet, it stayed there, it wasn't used, something to that effect. And so the state then presenting that gun to show the three-judge panel, I mean, I don't know why they would need to do that. And their theory in the reply brief was because he said he came home and found the people then, so that would show his lack of care, excuse me, that he should go get the gun, arm himself if the shooter was still there, et cetera. But that wasn't the defense statement of facts for the second trial. So the reason for admitting it wasn't the same anymore. It wasn't based on the same defense theory, statement of the facts anymore.
But even if it was error, how is it not harmless in the context of all the facts here?
It was prejudicial because it just showed that, again, like I said, if he could obtain one gun, he could obtain another gun. And nobody ever linked the gun found in the pond to him. There's no linkage here. But saying if he could get one gun, he could get another is saying, why couldn't he get another gun, the one found in the pond? But there's nothing linking him to that gun. Because any probative value was substantially outweighed by the danger of prejudice, of unfair prejudice in this case. If there are no further questions, I'll reserve the remaining time for rebuttal.
Thank you.
Thank you.
Ms. Concanon, good morning.
Good morning, Your Honors. Chief Justice Kennedy, and may it please the Court. Willa Concanon here on behalf of the state. Also with me is John Marshall, one of the lead trial prosecutors in this matter. We are here today to ask the Court to affirm the verdicts of the three-judge panel, finding this defendant guilty of 4 counts of aggravated murder and sentencing him to death for each of those counts for the murders of his 4 family members, his wife, Shalinderjit Kaur, his mother-in-law, Parmjit Kaur, his father-in-law, Hakikat Singh Panag, and his aunt-in-law, Amarjit Kaur. I'd like to start where counsel left off with the issue of the Beretta. This was a clear case of door opening by defense counsel's statements in opening. And it's very similar to Trimble, which was not only a capital case, but which was a jury case, where this court unanimously found that defense counsel's statements in opening opened the door to evidence of 19 firearms that the defendant possessed. And I submit that the case for admissibility here is much easier. We were in front of a 3-judge panel, and we were talking about 1 lawfully possessed firearm. And more than that, defense counsel's statements in opening here didn't just open the door, but they squarely placed the relevance of the Beretta in front of this trier of fact. The state did not mention the Beretta in its opening. Defense counsel did. Defense counsel stood up in opening and claimed that the Beretta was evidence of this defendant's innocence. And not only that, but defense counsel actually chastised the state for failing to mention the gun in its own opening. On page 26 of defense counsel's opening, the court will see, counsel said, please pay attention to some of the evidence that the prosecutor did not mention in their preview to you this morning, that Gurpreet had a lawful firearm in his closet that was not the murder weapon. Appellant is now asking this court to find that the firearm and the ammunition were of no consequence, and the state responding to his argument is reversible error. That is completely at odds with what this court said in State versus Trimble. Once counsel expressly stated that the Beretta was evidence of innocence, the state had the right to respond with relevant rebuttal evidence. And we did so not just with a responsive, relevant argument, but our argument and the evidence was about as far as you can get from a non-propensity argument when we're talking about firearms. The state contended that an innocent, law-abiding person would have retrieved this readily operable, lawfully possessed firearm to protect himself and his children if, as this defendant told police, he returned to his house to find his 4 family members on the ground, all bleeding from the head. And I want to address this argument that my opposing counsel made this morning, that argument by the state is somehow irrelevant in this trial, because in this trial, unlike the first trial, the defendant, in opening statement, his counsel placed him in the apartment. First of all, there are multiple statements from this defendant on police body cam and also in his call to 911 saying, I just got home and I found my family murdered, or found my family bleeding on the ground. And then he also tells the 911 operator and the police when they arrive that he's been in the apartment, that he's checked on family members, that he's tried to help them and give them water, and then more than that, he tells the police that he's checked the rest of the apartment. So not only is he saying he's in the apartment after this alleged other shooter has executed his family, but he's wandering around the apartment looking for this vicious murderer. And he then, according to him then, he's walked right by this readily accessible firearm. So those statements were at this trial, at both trials, and that did make it relevant. And even considering the changed defense at this trial that he was allegedly in the apartment witnessing these murders, he still maintained at this trial, in addition to the statements on the police body cam, he still maintained at this trial that he stayed in the apartment and that he was helping the victims, that he was touching them. And so it still remained relevant as the inference as to if you're in the apartment and you've witnessed these vicious murders, you're wandering around, you don't retrieve the firearm. It tends to show guilt, and it certainly rebuts the argument that the Beretta is evidence of innocence. And I just want to point out a few comparisons with the Trimble case and why our case is a much easier case for this court to affirm. First, like I said, it's a non-propensity argument. It's one firearm, and again, we emphasize repeatedly, this is a lawfully possessed firearm. It's not the murder weapon. The argument was just the opposite of a propensity argument. Secondly, we've got a 3-judge panel here, unlike in Trimble. In Trimble, it was a jury capital case. Here, we have a 3-judge panel, and this court has said many times that a 3-judge panel is presumed to consider evidence only for its proper purpose and not for propensity reasons. And then on top of that, even though this was a 3-judge panel, the prosecutor repeatedly gave a limiting instruction, both when he admitted the evidence and then at the conclusion of Sergeant Oakes' testimony, who talked about the Beretta, and asked the panel to only consider the Beretta for that limited purpose, that there was a readily operable firearm, and the defendant did not retrieve it. And that's all that was argued in closing, too, is that very limited non-propensity purpose. The prosecutor said, the Beretta handgun is found at the scene. It's not the murder weapon, but it's readily available for self-defense. What if the killer is in the house? What if he comes back to finish the job? The defendant did not get his gun because he is not concerned for his safety, because he is the killer. And I'd like to point out to the court the standard of review that we're asking the court to apply. I think the door opening here is shown even more so by the fact that we don't just have counsel mentioning the gun in opening. We have Sergeant Oaks testifying for 10 pages about this Beretta, and there's no objection. And then we have Sergeant Oaks, we have the prosecutor through Sergeant Oaks admitting 2 photographs, a photograph of the gun case and then the gun with the ammunition. Not only is there no objection to that, but defense counsel says, when she's asked, is there any objection to the photos, she says, no objection. So as to the photographs and the testimony about the Beretta, we assert that there is an affirmative waiver. It should not be addressed by the court. Not only was the door opened in opening, but then when that testimony came out, when the photographs of the gun came out, there was no objection at all. So that should be waiver. And we point the court to the case State versus Bethel, where, again, a capital case, and the defendant there raised an issue in opening statement. The state then brought out evidence of that issue in its case in chief, and there was no objection. And this court said the defendant did not object to this evidence. The defendant's attorneys first inserted this issue into the case in opening, and therefore the question is waived, and we will not address it. Now, regarding the physical exhibits.
Going back to that, so they've argued ineffective assistance of counsel. Is there any kind of worthwhile trial strategy to that?
I'm sorry, are you talking about
The Beretta.
the Beretta?
Mm-hmm.
I think that the Beretta was not an ineffective assistance of counsel claim. That was a trial error claim.
Okay.
Yeah,
Thank you.
they don't raise ineffective assistance with that. It's just a trial error claim.
All right, thank you.
Yeah.
You're arguing waiver, so I wanted to make sure.
Okay, thank you, Your Honor. So, and then just to finally turn to the actual physical exhibits of the gun, the door was open, but then there was an objection. So the standard of review would be the one that the court applied in Trimble, which is a very limited form of abuse of discretion. It just asks whether the trial court properly found that the Beretta evidence and arguments were responsive to the defense counsel's statements in opening. There should not be a separate 403A unfair prejudice evaluation, as the appellant is arguing today, because that's precisely the point of the door opening. If counsel chooses to inject an issue into the case, so long as the state's response is relevant, then that should end the inquiry. Finally, Your Honors, I submit that even if the court finds any error with the admission of this evidence, the court should find that it is unquestionably harmless for 2 reasons. One, as I just said, the physical exhibits were the only thing objected to at trial, and they are really cumulative of the testimony and photographs that are unobjected to, and that the court should consider as firmly in evidence, and any objection to those waived on appeal. And secondly, the fact is the Beretta did not affect this verdict. It was a very minor piece of evidence, and whether the court looks at it under plain error review or harmless error analysis, it was a very small piece of the state's case relative to the overwhelming evidence that we presented. And as the court knows from our extensive discussion in Proposition of Law Number 20, but just to briefly remind the court of some of that very compelling evidence, this defendant was in this apartment at the time of the shootings. There were 3 undisputed independent geolocation devices that placed him in that small apartment at the time of the shootings. And then there was counsel's admission in opening that he was there. And he was the only one that exited that apartment alive. He was totally uninjured himself, but he was covered in blood, including his wife's airborne blood spatter on the front of his pants and his shirt. He had gunshot residue on both of his hands. His bloody boots, which were admittedly his, were at his murdered wife's head with her blood and brain tissue on the boots. And his bloody footprints and boot prints were all over the scene. And then he immediately proceeded to call 911 and lie to the police, and then detectives claiming that he just got home, when in reality, that undisputed GPS and other geolocation data showed that he had been home for 29 minutes. And then on top of that compelling picture, which alone we submit gets you to proof beyond a reasonable doubt, on top of that, you have the neighbor's testimony. Several neighbors testified that, in their words, almost immediately after hearing gunshots, this appellant and nobody else furtively exited the back patio of that apartment and moved back and forth, suspiciously looking around, and leaned over the railing of the patio. That back patio, where the neighbors testified that they saw this appellant, it abuts a pond. Another neighbor that was standing close by, again, testified that seconds after hearing the gunshots, she heard a splash in that pond, again, where Singh's patio faces. The murder weapon was found in that pond. And then on top of that, you have this appellant's countless lies to detectives in his interview about the time he came home, when he called 911, his relationship with the victims, his lie about never going on the patio that night, his omitting substantial evidence of his guilt from the timeline that he gave them, and then his sudden hostility when he was asked for a gunshot residue swab. And there was powerful proof of his calculation as well. He sent his children out of the apartment that night with his cousins very deliberately, leaving the 4 victims alone. And when the young children returned with the cousins to the parking lot of that apartment and called this appellant and said, "We're here, we want to drop off the kids," without any explanation, this appellant said, "Leave, don't come in." This was 9:03. The kids are wanting to come back to the apartment. The defendant says, "No, leave." For no apparent reason, these young kids can't be dropped off, and then 15 minutes later, all the victims are dead. And finally, there was the motive. The state presented compelling motive that this defendant had a hostile relationship with his father-in-law over a multi-million-dollar property and had even assaulted the father-in-law over that dispute a couple months before the murders. And there was also undisputed evidence that this appellant had a double life with his mistress that he wanted to be with, that he bought a house just down the block from her 9 months before the murders, and his strained finances also showed he could no longer sustain that double life. In light of that compelling evidence, we asked the court to consider that any error here was harmless, and we asked the court to also consider the strength of that evidence in reviewing many of these propositions that are subject to either harmless or plain error review. If there are no questions about that, Your Honors, I'd like to turn to the question of the waiver. I'd like to first turn to the suggestion and proposition of law number 2 that the waiver was invalid. The defendant's written waiver here easily satisfied the requirements that this court has mandated for a valid capital jury waiver. The trial court's colloquy here was far more robust than required by this court to accomplish a valid waiver. And the appellant actually doesn't dispute this. He just says that this court should change its longstanding precedent and require a more extensive colloquy. This court has repeatedly declined to do this, including most recently in State versus Brinkman, a 2022 3-judge panel case where this court unanimously rejected some of the same arguments that this appellant is making today. Instead, this court has consistently applied 2 simple rules to to evaluate the validity of a capital jury waiver, starting in State versus Gels in 1990, and then, as I said, most recently reaffirmed in State versus Brinkman. The court has laid out two rules. First, a written jury waiver is presumed valid. This court has said a written jury waiver creates a rebuttable presumption that the waiver was knowing, intelligent, and voluntary, and it will not be set aside except on a plain showing that the waiver was not freely and intelligently made. And secondly, this court has long held that there is no requirement in Ohio for the trial court to interrogate a capital defendant to determine whether he or she is fully apprised of the right to a jury trial. Rather, 5 basic conditions are required, and these are set forth in the statute, 294505. And this court said that based on that statute, all that's required for a valid jury waiver is it must be in writing, it must be signed by the defendant, it must be filed, made part of the record, and made in open court after arraignment and the opportunity to consult with counsel. There's no question that all of that happened here and more. So there's no dispute by this appellant that those requirements were satisfied. And our position is that should be the end of the court's analysis, because that is all this court has required since 1990. And still on top of that, we have the trial judge conducting a comprehensive colloquy here, making sure that this defendant met during the waiver hearing twice with his counsel. And the appellant brings up today this suggestion that somehow because the appellant was using an interpreter in this matter, that should undermine the confidence in the validity of the waiver. We submit the court should reject that. There's nothing in this record that suggests that he didn't understand the waiver through the interpreter, and the trial court here went out of its way to make sure that the waiver was done with the full understanding of the interpreter here. In fact, this appellant's counsel were actually confident that he didn't need an interpreter to execute this waiver, because the record shows they showed up in court at this waiver hearing and they had visited the appellant in jail the week before and secured the written waiver with him in jail, had discussed it with him in jail, had had him execute the written waiver without the presence of an interpreter. So his own two counsel were confident that he understood this even without an interpreter. But then when we have the hearing, the trial judge very wisely says at the start of the hearing, did you meet with him with an interpreter? And counsel says, no, we didn't. He says, well, you're going to go out right now privately and you're going to talk with him through an interpreter. And that was done not only once, but twice. The court made sure that this appellant spoke with counsel through an interpreter before the waiver hearing started, and then again before the appellant signed the waiver. There's nothing in this record that suggests he didn't understand that, and there's nothing in there's 5 years of proceedings here where this appellant proceeded with an interpreter, and there's zero evidence in the record and none that he points to that suggests there was ever a misunderstanding. And I want to turn specifically to the question of whether the appellant was advised that he could withdraw at any time the jury waiver. This court rejected that argument in State versus Brinkman in 2022 and said that there's no procedural rule or statute that requires the court to give that advisement. But here, even though it's not required, again, the appellant would have understood this, because the trial judge is repeatedly saying during this waiver hearing, not actually during the colloquy, but at the end of the waiver hearing, the trial judge says, we're going to continue on with jury excuses. We're going to continue on as if we're having a jury trial here. I'm going to bring in a panel. We're going to continue with jury excuses in case this defendant has a change of heart at the last minute. Those are the judge's words at multiple hearings after this, at the waiver hearing, and then multiple hearings after that. So there's no question that the appellant would have understood he could withdraw the jury waiver. And then, contrary to what opposing counsel says in their brief on page 33, where they claim that the trial court never inquired of Mr. Singh whether he wanted to withdraw the waiver, that's simply untrue. On the first day of trial, again, even though it was not required, the very first thing that the presiding judge did on the panel was directly address this appellant, and this is on page 34 of the transcript from April 28, 2024. He directly addressed the appellant and asked him if he wished to confirm his jury waiver and proceed with a 3-judge panel. There's no question that this defendant understood he had that right. Next, I'd like to discuss the claim that there was a failure to advise the appellant that that his waiver meant that he would be sentenced by the 3-judge panel and not just that they wouldn't just be making a finding of guilt. Again, this is not required. It's not part of the 5 steps that the court has said are required. But in any event, the trial court did explain this to the defendant. And in fact, the trial court did better than that. The trial court actually explained to this appellant what the specific proceedings would be when you are sentenced by a 3-judge panel versus a jury. So the court said to the appellant, this is on page 30 of the waiver hearing, if you waive, let me back up for a second, I'm sorry. At the start of the hearing, the prosecutor even said to the court, can you please advise the defendant that if he waives a jury, the 3-judge panel will decide his guilt and his sentence, including a possible death sentence, only by a unanimous verdict. So the trial prosecutor has asked the court to give that advisement. Then the court does that. The court says to this appellant, do you understand that even if a jury reaches a verdict and finds that the aggravating circumstance outweighs by proof beyond a reasonable doubt, that the trial court, meaning me as the judge, will still go on and independently review that sentence? And the court says to this appellant, do you understand that? The appellant says yes. And then the trial court gets into even more detail and says, by the way, you don't get that luxury in a 3-judge panel. If the 3-judge panel unanimously finds that the aggravating circumstance outweighs by proof beyond a reasonable doubt the mitigating factors, there's no independent review. And if we as a 3-judge panel would impose a sentence of death, that's it. Do you understand that? And the appellant says yes. So we submit that this advisement was given, even though it was not required. And if there are no questions about the validity of the waiver, I'd like to turn to the question of whether this was ineffective assistance of counsel to waive a jury trial in a capital case. This is both propositions of law number 3 and 4. This court has said in cases like State versus Belton, in rejecting a very similar claim to this one, that under Strickland, it will indulge a strong presumption that counsel's advice to waive a capital jury trial is a sound strategy. This court has also said that it's a classic example of strategic trial judgment to waive a capital jury. And the court has pointed in 2 capital cases, Hunter and Belton, to a strategic, reasonable basis that exists in virtually every capital case for waiving a jury trial. And that is the necessarily gruesome and emotional evidence that comes in a capital case. The court in Hunter and then again in Belton said that it can be objectively reasonable to waive a jury in a capital case just based alone on the horrific facts necessarily involved. In Belton, the evidence included videotape of the victim being executed, and the court there said that counsel may have reasonably concluded a 3-judge panel was less likely than a jury to be emotionally swayed. And then similarly in Hunter, this court concluded that it was a reasonable tactical decision because of the horrific nature of the charges involving the death of a child. Here, too, the murders and the victims' injuries were horrific, even for a capital case. This defendant was charged with the cold-blooded execution-style murders of 4 helpless family members, including his young wife, the mother of his 3 young children. The victims were shot multiple times in the face and the head, and the injuries were obviously terrible. In fact, the record here shows that one of the jurors at the first trial fainted after seeing photos of the victims. Given the horrific nature of this case, like in Hunter and Belton, counsel here had an objectively reasonable basis to recommend that a 3-judge panel would be able to view this evidence more dispassionately in reaching a verdict, and particularly whether to impose the death penalty and to be able to separate out the evidence from both phases. And we submit that this record supports another basis for counsel having an objective reason that shows a calculated strategy, which is that at this point, the defendant already knew who was going to be on the panel. The drawing of this panel happened early on in the case. He knew exactly who would be on it. He had been in front of this presiding judge, again, through a whole trial, through years of pretrial proceedings, and he could have made the decision that the judge had been respectful of the defense team and the defendant, had particularly safeguarded this defendant's rights. This judge had placed on the record, had freely discussed that he was previously a capital defender himself. He showed that he took very seriously a capital defender's rights. And based on that, counsel could have reasonably concluded that not only is a 3-judge panel better equipped to fairly view the evidence, but also the presiding judge would be particularly well equipped to set aside his emotion as a trier of fact. And I want to just briefly address this suggestion that the fact that there was a hung jury at the first trial would have somehow compelled the conclusion that that was the only reasonable choice going forward with the second trial. I think that ignores the full record here. I mean, just like this statistics argument about, 1 out of 12 chances is better than 3 chances, it ignores the variables that a competent counsel would have considered. The mere fact of a hung jury doesn't predict what's going to happen before a different jury. And defense counsel here knew exactly what the circumstances of the hung jury were. It was a very unusual situation. There was a whole record of what was going on with this jury. And as was pointed out, there was actually an 11-to-1 vote to convict. The record shows that the 11 jurors had voted guilty on all 4 aggravated murder counts and specifications, and they reached that verdict very quickly. And the evidence also showed that that one holdout juror it was a very unusual circumstance. The juror was arguing with people. The juror asked to be discharged. That circumstance would not have given counsel any confidence that a jury was the more strategic, obvious way to go. Your Honors, the state asks, if there's no more questions, the state asks this court to affirm the guilt verdicts and the verdicts of death. In this case, after its independent weighing, we assert that the court will come to the conclusion that a death sentence is the just verdict here.
Thank you.
Thank you.
Ms. Sanford, you have 7 minutes, 38 seconds.
Thank you. A few things from the state's argument about the Beretta, Proposition 1. They're saying that showed, I don't remember if the word was innocence, I don't remember, but the fact that he told the police he came home and found the victims deceased. At second trial, his counsel admitted to those lies, said, yes, that was a lie. And so then going forward with the state having the same argument for admitting the Beretta, when they said in opening statement those were lies, then it's really not relevant to the case anymore, because he said, I lied to the police, and obviously his theory now is different than first trial counsel. So that's our argument, that was why that was prejudicial to him. Also statements were made about the neighbors and their testimony about timing and things, but also neighbors gave different descriptions of a person they saw running away from there. It was long pants and a long shirt or sweatshirt that was not what Mr. Singh was wearing. And a factual part was brought up again about how the cousin, Harmanjot, did not drop off the kids when they got back to the apartment that night, that she called Mr. Singh instead and took them back to their place. But Harmanjot also testified that she talked to Shalinderjit, the mother of the children, who wanted to know where her kids were and when are they coming home, yet Harman did not take the kids there after that conversation as well. She also was Kuldeep's daughter, the one of the people who defense counsel said were behind the murders. And in the state's closing at sentencing, they said maybe his uncle orchestrated this. So there's still some question then about what happened here. And also talked about not having an interpreter. The second trial counsel did not have an interpreter when discussing the waiver, and that showed, but our argument, that shows their ineffectiveness. For 5 years, the state said he had an interpreter, and then why wouldn't you have one when you're advising him about one of the most important decisions he's ever going to make? And again, the confusion about the jury waiver is that, again, you're continuing on with the jury, with the process, having the excuses, questionnaires, having them show up. That's going to add to the confusion, because not only Mr. Singh, English is not his native language, but again, like I said before, he's not going to understand things like we do. He's going to think they're still showing up. I had a jury at the first trial. This all is familiar to what happened to me at the first trial, and they're still going to be here. So that would add to his confusion about knowing that he's waiving a jury. And the likening this case to Hunter and Belton, they didn't have a prior hung jury. And again, that juror, the first jury saw all the gruesome and emotional evidence, yet still came back hung jury. One juror fainting, still a hung jury. A hung jury was certainly better. A hung jury of 11-1 was still better than 3-1 with the 3-judge panel. And he knew who would be on the panel, so that again shows another reason to have the jury, just lack of diversity on the panel, the similar makeup of the of the judges, all working at the same place, doing the same thing, having the same familiarity with defendants who come in, say one thing, but you can see through it, like the state was saying at their one argument at trial. And one thing I want to talk about, Proposition 4, the statement where he said about he believes there was ample evidence to convict, he starts it out with, I agree with the state that I believe there was ample evidence. The state wasn't saying there's ample evidence to acquit him. Their argument was there's ample evidence to convict, and he's agreeing with the state at that statement there. Another statement he makes for why he should have been recused is that when he talks about at the April 22nd, 2024 hearing, he says that when first trial counsel, Mr. Rickers, stood up and said 3 masked men with baseball bats broke into the apartment and committed this offense, and I think everybody in this room was stunned by that comment. And he shouldn't be stunned by anything. If he's going to be an impartial trier of fact, he shouldn't be stunned by things like that, and makes this statement in open court, was stunned by that. And again, saying, that defense counsel are at their own peril if they say or try to present evidence that they can't prove, meaning evidence about the 2 people from India who counsel at both trials claimed were behind all this. So he's already determined that that defense isn't valid. He was stunned by first trial counsel's statement of what happened, and then he's also agreeing that there was ample evidence. So he is no longer going to be an impartial trier of fact in the second trial. Trial counsel were inadequate throughout every stage of this trial. And also, it was a recipe for disaster for Mr. Singh, from waiving jury to their performance during the trial to the mitigation phase. And we know there is a reasonable probability of a different outcome because there was one at the first trial. And if there's nothing more, I will conclude.
Thank you.
Thank you.
We'll take the matter under advisement. You'll receive a decision from the court.